Coach DC News. Constitutional Shockwave. In a quiet but seismic move, the Supreme Court of the United States issued a 6-3 emergency ruling in Trump versus Cassa, Inc. that fundamentally alters how constitutional rights are protected and who gets protected at all. Delivered via the court's shadow docket, the decision abruptly ends the era of nationwide injunctions, stripping individual federal judges of the power to freeze laws or executive actions across the entire country while cases are litigated. For decades, a single district judge could halt a federal policy nationwide, whether on immigration, healthcare, or firearms, before a full trial ever occurred. That power is now gone. Writing for the majority, Amy Coney Barrett, joined by John Roberts, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Clarence Thomas, argued that the Judiciary Act of 1789 never authorized courts to protect people who are not parties to a lawsuit. In short, courts may now issue relief only for those who sue, no more, no less. Justice Gorsuch underscored that historically, injunctions were narrow by design, confined to the litigants before the court. Justice Thomas went further, calling nationwide injunctions a modern invention that fuels forum shopping, where plaintiffs hunt for friendly judges to impose national outcomes from a single courtroom. The majority's message is blunt. The judiciary overreached, and the correction is overdue. The dissent, led by Sonia Sotomayor, issued a stark warning. Without universal relief, unconstitutional policies may remain enforceable for months or years as individual cases crawl through the courts. Constitutional rights, they argue, risk becoming pay-to-play, available only to those with the resources to sue repeatedly in multiple jurisdictions. The fallout was immediate. Attorneys general from 18 states filed emergency motions to either preserve existing injunctions or activate laws that had been frozen. Immigration enforcement may now vary by zip code. Civil rights litigation is poised to become slower, costlier, and fragmented. Corporations face a compliance nightmare as federal rules potentially differ from region to region. And critics warn of a chilling effect. Judges may hesitate to block unconstitutional actions at all, knowing their orders no longer carry national weight. This ruling marks a turning point. Constitutional law in America has entered a fragmented era, where geography matters, lawsuits multiply, and rights may hinge less on principle than on proximity and resources. Call it restraint, call it correction. Either way, the rules of the game just changed, and the country will be living with the consequences for years to come. Coach out. Peace.